to begin our class session. So please have a seat and make yourself comfortable. And before that, I would like to remind all the participants to turn on your camera and active during the class. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan untuk kita semua. Hello everyone, good afternoon from Indonesia. Welcome back to summer course Lex Proficia 2021. My name is Faraziana Tisha Putri and you can call me Tisha, and I will be your host for today's sessions. Thank you very much for all the participants for your enthusiasm to join these sessions. It is indeed a pleasure to have all of you today. First of all, let us give our praise to our God. Due to his blessing and mercy, we can still gather virtually in this lovely afternoon. So let us start today with praise. So the sessions will run well without any obstacle at all. Let the pray begin. Amen. Thank you. Proceed to the next agenda. Now we come into the most awaited sections, that is the class sessions with our special speaker, the one and only Dr. Ayu Putrianti SHM Hum, the Indonesian Procedure Law Lecturer in Universitas Diponegoro. And today we have an interesting topic. We're talking about introduction to Indonesian e-court that will be guided by our moderator, Mr. Zil ID SHMH. But before that, I would like to introduce our moderator based on his CV. Okay, we have Mr. Zil ID SHMH, the lecturer at Faculty of Law Universitas Diponegoro, with the specific teaching courses in civil procedural law, litigation skills, and arbitrations and alternative dispute resolutions. He born on 20 February 1993. He obtained his undergraduate and master degree at Faculty of Law, Universitas Gadjah Mada, Indonesia. And he also have a lot of publication. And the last is the Natural Disaster Insurance for Indonesian Disaster Management, Advances in Environmental Science Journal, written in 2020, and the e-litigations as the amenities for the principle of contained Justice Manifestations of Civil Jurisdictions in Indonesia, written in 2021. All right, without any further ado, ladies and gentlemen, please welcome Mr. Zil ID SHMH.
Okay, thank you, Tisha. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon for all the participants of Lex Proficia 2021, held by Faculty of Law Universitas Diponegoro. It's a pleasure for me to be here with you all in this very blessed forum. Before that, let me introduce myself. I'm Zil ID. You can call me Zil. I'm a lecturer in Faculty of Law Universitas Diponegoro, specifically in Procedural Law Department. Today, in this very good session, we have a very interesting topic regarding the Indonesian e-court or electronic court. So in 2018, the Supreme Court of Indonesia, or we call it here Mahkamah Agung Indonesia, launched a system called e-court, or the official name is Electronic Justice System. This system aims to create a better administrative in the court, so it can be cheaper, more simple, and also accessible for everyone in this country. The role of e-court is getting significant to be discussed. Why? Because in this pandemic era, we are no longer flexible to go outside, especially in the place that a lot of people there or in the crowd. Of course, court is one of a public place that a lot of people come to, and also, especially in the big cities, court is considerably a really crowded place, so we have to avoid it. And I think there e-court could be an instrument to minimize the crowd, and if we see it in a broader perspective, it could minimize the spread of the virus. Okay, I will not talk about it further because it will be on our speaker's presentation. But before we proceed, let me read the curriculum vitae of our speakers. Her name is Dr. Ayu Putrianti SIM, as the MC described before. She is very expert in procedural law, especially in administrative procedural law, because she is a lecturer in procedural law department. She is in the same department with me, Bu Ayu. And she was born in Semarang, 15 March 1969. And she has a lot of teaching subjects, for example, introduction to Indonesian law, administrative law, administrative procedural law, and any others related subjects. On her educational background, she finished her bachelor, master, and doctoral degree in Universitas Diponegoro Fakultas Hukum. Also, she has a lot of publications, and it will take time if I read all of the list, but I only perhaps read the relatable with this topic of e-court. She has the jurisprudence of state administrative court in the development of state administrative law. That's the article in Balitbang Journal, Jurnal Penelitian Hukum, and also Indonesian Administrative E-Court Regulation towards Digitalization and E-Government. And the last, she has the competence of administrative court and administrative justice published in Fiat Justitia Journal. Okay, without any further comment, I will give the chance to Bu Ayu to present her presentation, perhaps 30 until 45 minutes, Bu Ayu. To Bu Ayu, the time is yours.
Okay. Thank you, Tisha. Thank you, Mr. Sil ID. Yeah. Good afternoon, everybody. Can you hear me, Sil?
Yes, Bu
Clearly?
Ayu.
Okay. Okay. My name is Ayu. Yeah. Usually, I teach the administrative court in the Faculty of Law, Diponegoro University. In this occasion, I would like to share about the Indonesian e-court. Okay, first of all, what do you know about the e-court, audience? What do you know about the e-court? Anyone would like to answer my questions? What do you know about the e-court?
Yeah, perhaps someone to answer Bu Ayu questions. Just feel free to speak up.
Okay. The one answer this first. I will begin with the first slide. This is the title. It's Indonesian e-court. Maybe after this lecture, you will get to know more about what is the e-court. Next, please, Sil. Yeah, the judicial power system in Indonesia is based on Article 24 of the 1945 Constitution of Indonesia. Judicial power is exercised by the Supreme Court and the Constitutional Court. Yeah. Under the Supreme Court, there are 4 courts, namely general courts, and the religious court, military court, and then administrative court. All 4 courts are under the Supreme Court. Next, please. Yeah, and the establishment of each judicial institution with like I have namely before, the general court, the religious court, military court, and administrative court. Each are based on its law, its regulation. For example, the administrative court is formed by the law number 5 of 1986 of administrative court, and twice amendment by the law number 9 2004 and the law number 51 2009. This is for example. And in accordance with the development of the information of technology in globalization, yeah, also in Indonesia, The judiciary system in Indonesia also has to adjust with the development. We have to adjust and follow with the development properly. The Supreme Court blueprint of Indonesia in 2010 until 2035, yeah, it is confirmed that the Supreme Court upholds the transparency of case examination in the Supreme Court, because this is to achieve the low cost and a simple and judicial accountability. Yeah. So in the starting point is the blueprint of Supreme Court. Yeah. And then after that, started to build the judiciary reform based on information technology. This is very important in the era of digitalization for us, yeah, to adjust and to follow this properly. So in the next step is the annual year of Indonesia's Supreme Court 2010 and then 2020. This is the annual year of Indonesia Supreme Court 2010 and 2020. Yeah. As well, the starting point for building information technology-based judiciary. Yeah. So starting from the 2010, the Supreme Court of Indonesia and also the Constitutional Court of Indonesia also preparing for the technology-based judiciary. The 2000 Supreme Court's annual report emphasized that advanced information technology must utilize the improved public services, including that the public can access decision in all judicial bodies in Indonesia. For example, since 2015, 2014, yeah, the citizenships can access all the judge verdict in all the level of the court in Indonesia by click the Supreme Court icon only. Yeah, we thought we have to come to the court and where we have to ask them to, please sir, we can we ask the verdict, just verdict for this case, number case, and this and this. So it is no need longer anymore. Just we can say to the go to the Supreme Court, yeah, and then to the Supreme Court website, and then we can get all the judge verdict for all level of the courts and any type of courts in Indonesia. So next, please. The Supreme Court efforts to implement advances in information technology is to support the performance of the judiciary gradually. Yeah, this is also began with the issuance of the Supreme Court Regulation number 3 in 2018 about the electronic case information. Yeah, this is the first regulation by the Supreme Court of Indonesia about the electronic case information. And then this is about amended. It was amended by the Supreme Court Regulation number 1 of 2019 about the electronic case administration and court. The difference is in the Supreme Court Regulation number 3, 2018, it's only regulated about the electronic case administration. But in the Supreme Court number 1, 2019, yeah, it was regulated about the electronic case administration and court. Court means about the how to proceed, yeah, how to proceed in the court electronically. These are the differences. And the third is amended again by the Supreme Court number 4, 2020. Actually, the Supreme Court number 4 in 2019, I think. 2020, it is about the electronic case administration and trial in criminal case. Yeah, so the differences is that the Supreme Court Regulation number 4, 2020, yeah, is regulated about the e-court for the criminal case. Because previously in the Supreme Court number 1, 2019, yeah, the Supreme Court does not regulate, did not regulate about the criminal case procedural. It is only regulated about the proceed in general court and also in administrative court, except for the penal or criminal cases. So e-court in Indonesia, basically based on the Supreme Court number 1, 2019, and also the Supreme Court number 4, 2020. Next, please. Based on the principle, the e-court in Indonesia, based on the principle of constante justitiae, that the court should be done promptly, easily affordable. It is based on the article number 2 of the law number 48 and 2009 of the judicial power in Indonesia. On the other hand, the development of the information technology in the era of the judicial system is to follow and adjust itself. Just a minute, I will try to move this one. The development of information technology in the era of 4.0 and the judicial system is to follow and adjust itself, yeah, with the modernization in the era of 5.0 also. So the the Supreme Court, yeah, has to adjust about it. The government policy is to attract more investors. Should be followed with the transparency of law enforcement. As you also know that to get more investor in Indonesia, there should be the transparency of law enforcement. This is also help the governments, yeah, to get more investor in Indonesia. So they would like to more invest here because they will know and they will see that the law enforcement in Indonesia is transparency and is very easy to go. And the second, yeah, the fourth is the referring to the SDGs number 16. This is also support the SDGs number 16, that is to promote a peaceful and inclusive societies of social development and provide justice to all, and also to build effective, accountable, and institution at all levels. As you also already know that the Sustainable Development Goals number 16 is about the justice for all. Yeah, this is very important also to our Indonesian, that we have to support and to promote the peaceful for everyone, as the tagline of the SDGs, that the no one left behind. So the government also tries to implement the SDGs in judicial system. Thus, some development are made to bring access to justice for citizens. Using the electronic courts, hopefully the people or the public, yeah, will use this efficiently. Next, please. This is about the e-court again, yeah, as I also said, that the SDGs tagline that leave no one behind. That it means that we have to come together, yeah, to face the justice, and also everyone has right to get the justice. And the e-court aims to provide and promote justice to all, for all. Everyone has rights. Everyone has rights to get justice, yeah. And the government also has to make any policy to make it progress for the e-court. And the several obstacles also appears about, first, the lack of knowledge about court proceeding. This is very important, yeah. Not all the people knows how to court proceeding is, how the difficulty is, yeah. And then also lack of education also. We have to we know that the lack of education also made people difficult for them to understand and to learn about the court proceeding. They will ask how to proceed in the court. They doesn't know how to do it. They doesn't know that. And the poverty also, yeah. It is when the people, yeah, they have problems about an administrative court, for example, and as a plaintiff, yeah, but the defendant is the resident, for example, in Jakarta, yeah. But on the other hand, the plaintiff also lived in Indonesia, but in another island, yeah, far from Jakarta, so it is difficult, yeah, to reach Jakarta, and he also get difficulties, yeah, because of he has no money and he has lack education, yeah. It is very difficult for them. And also some discrimination against women and girls, and also about the hunger. This is also from the SDGs also about how we fight for the discrimination against women and girl for the access to justice for them also. So the government committed to make a fast track progress to reach and fulfill the SDGs in every context. There are 17 goals, if I'm not mistaken, about in SDGs goals, yeah, and the access to justice 16. And the government of Indonesia established the pillars based on 17 goals of SDGs. For example, 4 pillars are the social, economy, and for environment, law, and governance. Next, please. About the Indonesian e-court, yeah, based on the Act number 14, 2009 of judiciary system, yeah, the court should be done promptly, easily, and affordably. So as I have already mentioned before, there are 3 Supreme Court, yeah, which all are supported the Indonesian court and initiated the first of the e-court in Indonesia. The last one is the Supreme Court Regulation number 4 2020 of electronic case administration and the trial in criminal cases. The Supreme Court was the last one, yeah, because it also takes some times, yeah, also make some times to prepare the Supreme Court regulation for criminal cases because it is difficult also, yeah. It has to coordinate with the some institution. Next, please. Under the Supreme Court, there are 4 courts, and all courts have already implemented the e-court system in Indonesia. Under the general courts, yeah, there are some specialized courts. They also implemented the e-court, yeah, like the business court, yeah, and then religion court. There is no specialized court. Administrative court, there is also a specialized court for the tax court. It is also implemented the e-court, and military court also implemented the e-court. For the manual book of e-court, we can see and learn from the website of the e-court of the Supreme Court of the Indonesia. Next, please. From the website of the Supreme Court of Indonesia, number of courts, 332 for general courts, and the active e-courts, all the general courts have active all the e-courts. So does the religion court, yeah, 412, and the administrative court, only 30 courts. The number of court of in administrative court, only 30 in Indonesia. So it all active in e-courts. There is no number for the military court, yeah. There's no number for the military court at the website. Next, please. This is the e-court process in Indonesia, yeah. The first time is the e-filing online registration. In this e-filing registration, yeah, the case registration by the registered users and other users. Registered users means the lawyer. This is called registered user, and the other user. Other users like the in-house lawyer, yeah, or some other people himself would like to represent by himself only, not using the advocate or not using the lawyers. It is possible for us, yeah, to represent ourselves. And then they are logging into their account. We have to make an account first at the e-filing. Second is the user has to input the party's data. Me, for example, I'm the other user, so I have to input. I have to input all the data of my defendant, yeah. So then I also upload the lawsuit soft file as well as the principal approval letter for proceeding electronically. It is very important, yeah, because the court will check, yeah, and will prepare all the document after we upload all the document. After case registration successfully registered and upload, yeah, and then the users will receive an estimate down payment court fee. This estimate down payment court fee, it means that I have to make the next step in e-payment. Yeah, e-payment means in advance online payment. I have to make payment. I have to make payment addressed to the court bank and account electronically. So after I make the payment, yeah, after the payment completed, the lawsuit will automatically be seen in a court, can be seen in a court system at the aimed court. For example, I goes to the administrative court. I'm the plaintiff, yeah. So I have made the user's account, yeah, user's account, and then I make the e-payment in advance online payment. After I complete my payment, and then the case automatically can be seen in the court system. So the administrative court, they will preparing for the court for me for the next. After the data input, yeah, and verified by the court, yeah, based on my input data, the first when I filling the online registration, the users will automatically get a notification informed by the court. It means that the court will inform to me, yeah, that the lawsuit has been successfully registered in their system. So after I made the e-filing and then I made the e-payment, yeah, and then the e-summons. What is the e-summon? E-summon is the parties according will receive a summon letter based on their electronic domicile. Yeah. Previously, before not in the e-court system, the summons will be sent by post. Yeah. So it is very different since now we are using electronic card. This is based will be sent to electronic domicile. After the e-summon received by the parties, yeah, the parties, and then the next step is the e-litigation. E-litigation means that the trial in online. What is consist of the on e-litigation? Litigation usually consists that both parties are summoned in the courtroom. Yeah, both parties are joined in the courtroom. Yeah, based on the date of the trial already summoned in the letter. Yeah, and then after that, the answer, the reply of the parties. Yeah, submit their electronic documents in the application. All the documents should be submitted electronically. And then about the evidentiary proceed. What about the evidentiary proceed? Follows its procedural law. In the Supreme Court number 1, 2019, yeah, it is written that all the evidentiary proceed is follows for its regulation for each court. It is different regulation between the general court and the administrative court procedural law. As we also know, this is the private law, and the administrative court is the public law. Yeah, so they have its different evidentiary process. Yeah, the importance of why the parties have to attend at the evidentiary trial as an instrument to show that the original documents from the documents evidence. It means that all parties have to see, yeah, they have to see the documents is all are original one. And the chief of court, yeah, will, if the problem will come, yeah, the problem will come if when the witness is not in the same area, in the same city with the court or with the parties. So what about this? Yeah, how to manage this one? The witness testimony is the important part also in the evidentiary process. So how to make it? The chief of court, when the court is held, yeah, was held, will ask the assistance to the other court, where the witness domicile, in order to appoint a judge, yeah, who will take the witness oath and supervise the witness when he or she giving the testimony through the video conferences. So for example is I'm the plaintiff, yeah. I'm the plaintiff in a private law, in a private case. I'm the plaintiff in a private case, and the Mr. Seal ID is the defendant. Yeah, is the defendant. So he lives in Padang, Sumatera Barat, West Sumatra, and I live here in Semarang, Central Java. So he is the witness. It is very difficult for him to reach to Semarang because of this pandemic COVID. So the chief of court in Semarang, yeah, will ask assistance to the court in Sumatra, West Sumatra, yeah, as Mr. Seal domicile in Sumatra, in order the chief of court in West Sumatra to ask the judge, to point the judge, yeah, to come to see Mr. Seal ID and to take his oath and giving testimony. After the process, yeah, the chief of court in the West Sumatra have to send all the documents to the chief of court in Semarang. So it will get more process. Yeah, this is for example. And then after all the evidentiary process finished, yeah, and then we go to the electronic conclusion. The conclusion is the paperless also, because an electronic e-court, they upload the document to the e-court. Yeah, application the e-court, the conclusion by each party, both the plaintiff or the defendant. Yeah, defendant should they submit the document not later than the day at the time of trial, according to the court calendar, which already decided before. And then after the conclusion, yeah, the judge will give the judge verdict. The judge opening the trial, and then the judge will reading out the verdict. The verdict's copy will be uploaded to the e-court system application and also sent to the parties. Next, please. This is like I already tell before about the e-court system. The registered user, yeah, it can be the advocate, whomsoever get verified by the system. Usually it must be the advocate, and also the another user. Other user is like me, if I want to represent myself only, yeah. And then also all the process in the courtroom are supported by the information technology and communication. An e-domicile is a verified electronic domicile, as already registered and input in the data of the court. Next, please. E-court is an all trial procedure follow its regulation of the court litigation starts with the delivering the documents to the not later than the trial day to the parties. When the parties fail to deliver the documents without any legal reason, then based on the judge's appraisal, it means that as do not exercising their rights properly for the parties. If the party agreed to use an expert witness using the court infrastructure, so all costs will be charged to the plaintiff. All costs will be charged to the plaintiff. And the judge verdicts are delivered electronically and in accordance with the court procedures. And then next, please. This is before the Supreme Court number 4, 2020 published. Yeah, due to the COVID-19, the Supreme Court issued a letter number 379 DGUPS 003 2020 on March 27, 2020 regarding the teleconference of penal procedure. This letter, yeah, became before the Supreme Court number 4 of 2020 issued. So this is about the coordination between the court also and the prosecutor, yeah, and the jailhouse to organize the litigation process. Because in penal process, they have a different procedure, as we already know, yeah. They have the prosecutor and the jailhouse to organize it all. So it is difficult to make the same proceeding based on the based on the Supreme Court number 1, 2019. So it takes a little bit longer, yeah, for the Supreme Court to preparing this Supreme Court number 4 in 2020. Next, please. Oh, so this is for the Supreme Court number 4, 2020. There are general courts. General courts, yeah, organize every needs functions. That's a judiciary body based on law number 14. So there are also prosecutor. Prosecutor, as we already know, this is organized every needs function text of the general attorney bodies, yeah, based on the regulation and implements the monitoring evaluation of the teleconference. And the jailhouse, they organize the prisoner based on the regulation, maintains the safety and the order of the teleconference. Because for to avoid the spread of the COVID, maybe the prisoner will not come to the court, yeah, will not come to the general court. So they only stay in the jailhouse, yeah, accompanied by the prosecutor, maybe, yeah, there should be accompanied by the prosecutor or by the police or by the jailhouse officer. So it is different with the general courts for the private law or like the administrative court. Next, please. In Semarang, yeah, about the general court, religion court, and administrative court in Semarang, they have already supported the implementation of the e-court using the virtual account to conduct the e-payment and preparing relevant devices to be connected to the court, and the live video, books, banner of e-court, yeah. So in the waiting room, so the public, yeah, they can see, they can learn from the live video, yeah, how to proceed in the e-court. Yeah, and then complete information of the case can be accessed through the IPP website. It is very easy for us to access these websites, as we can see. For example, today, which number goes to the court? Yeah, which number case number this and number this go to the court, and also until which level they have to go to the today, which level for this case, yeah. And then we can learn also about how to proceed in the e-court. Next, please. Okay, thank you for today. Okay, thank you, Mr. Phil. It is finished. Thank you, everybody.
Okay. Thank you for Dr. Ayu Putrianti for the very interesting and very nice presentation regarding the Indonesian e-court. What can we conclude is that e-court actually has a lot of features there. The first one is e-filing. This is where you register your case. From previously, you have to go directly to the court to bring your case, bring your documents, and then you register directly to the officer in the court. Now you can do it online. And after that, also there are e-payment features in e-court. It is related to the payment, so you can pay it online. As we know that we have so many improvement in e-wallet, so perhaps the payment process is now expected to be getting easier. And also we have e-summons. E-summons is the features that regarding the how to summon the people from previously we have to send it the letter directly to the people now or the person. Now we just do it by online or use electronic domicile as Bu Ayu stated before. And the last feature of e-court is e-litigation or electronic trial. So we can have our trial in online or perhaps using many platforms, perhaps Zoom and any other platforms. And also, what can I or what can we see or what can we conclude from Bu Ayu presentation is now e-court is available for almost every court. Yeah, it is a religion court, general court, and also administrative court. So perhaps that's what can I conclude now. I give the participants, all of our participants, a chance, opportunity to asking a question, please. You can write down the questions in the chat box, or perhaps you would like or you prefer to asking the question directly, it is also uh, possible. Is there any questions regarding the presentation of Bu Ayu? Please, because in the chat box, I don't see any question. Perhaps now is the time to asking question if there's any. Okay, Bu Ayu, perhaps to stimulate the participant, I would like to
Okay.
ask a questions. Bu Ayu, I know that you conduct many research in field of administrative court, perhaps in e-court too. What I want to ask is, how do you think about e-court system? I mean, e-court's relation with the pandemic situation. It is effective that e-court can make the efficiency in the court. I mean, as I stated in the opening, that in this pandemic era, we are restricted to go to the place, to the public places that a lot of people there, or we have to avoid crowds. So as we know, court is a public place that all of the people come to the court with their every particular business or claim or any other thing. That what I'm trying to ask is, what do you think? How do you think the effectiveness of the court in our court? Perhaps that's who are you?
Okay, thank you, Mr. Sil. I will try to ask. In my opinion, the e-court in the during the pandemic of it is effective without ignoring their rights to get access to justice. Yeah, it is effective, but also it is some obstacles. Yeah, for if I also mentioned in my presentation that maybe because the lack of education, yeah, their lack of education also, and then about also if they live far away from the city, yeah, we also know that in Indonesia region, yeah, there are also some difficulties to reach the nearest city, yeah, the nearest city. It is also far, also difficult, yeah. So, and the next is also the lack of maybe the information technology in their area. The internet also is not good. Also, sometimes it takes down. Yeah, it is makes difficult if someone would like to make the file dispute, or also if they want to become the witnesses or something like that. It is difficulties, but mostly it is effective. Yeah, to avoid crowded and to get access to justice. Anything else? I can hear you, Mr. Zil.
Okay,
Okay.
sorry.
Yeah, clearly.
So the answer is very good, and I think it's very understandable that the court is already good, but it is still a room for improvement, so because there is still
Yeah.
an obstacles in their implementation. So I think this is should be a suggestion for the stakeholders.
Yeah. 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 People maybe they do not know, yeah, how to proceed in the e-court. Yeah. They think in their mind, if I have a problem, I have a case, yeah, so I have to come to the court, yeah, I have to make a file, yeah, to make a file in lawsuit. They do not know that it can be made by only submit, yeah, in upload. It is difficult maybe for them to understand and to learn about it, especially for them with the lack of education. They have to be accompanied.
Okay, thank you, Bu Ayu. So now we
Yeah.
have a question, and I will read it for you.
Yeah.
The question is from Danish from UKM. The question
Yeah.
is, does e-court able to produce fast justice, especially in criminal court, where duration of trial might take a long time? So
Okay.
it is regarding the e-court in criminal case, where the
Okay.
duration of trial might take a long time, perhaps because of the
Okay.
proof and everything. Please, Bu Ayu, answer the
Okay.
question from Danish.
Thank you, Dennis, from the UKM. I will try to ask. Does e-court able to produce fast justice, especially in criminal court, where duration of trial might take a long time? So far as I know, no. It cannot produce fast justice because all the procedure in criminal law, yeah, also in administrative court, also in private law, also has to follow the basic regulation about the criminal case. So it is not able to produce fast justice. It also has to obey the regulations. The based regulation for the criminal court is how long for the days is they have to follow it. It cannot become more faster like that. No, Dennis, it is not produce fast justice. As I already know, the Supreme Court already gave for all the trial process, trial process except for criminal case in Indonesia, in Indonesia only, that for administrative court, they have give 5 months. In 5 months, the court has to finish the case in the level 1, for example. But it is not. It is an exceptional for the criminal court, Dennis, in Indonesia. No. Next, please.
Okay, this is the answer for Dani's question. Perhaps if there is another question, Dennis, you can put it or write it down again in the chat box. Next question is from Shahira from Taylor's University. It is quite impressive and innovative for Indonesia to have e-court, especially since it will be useful during the pandemic. My question is, what happens if there is a connection issue during the trial or the connection signal?
So what does it mean, the connection issue?
Perhaps when we have like this Zoom meeting, so there is a connection.
The bad connection,
yeah.
Okay.
Perhaps
Nah,
something like that.
it is also problem. Shahira from the Taylor University. Thank you for your questions. Yeah, it is. I also explained about the obstacle. Yeah, in the first time about the bad internet also in Indonesia. What happens if there is a connection issue? So the judges, the Supreme Court have already regulated that it maybe can postpone, and then try again for another day. But the postpone, with the legal reasoning. The legal reasoning is about the bad connection or the connection is poor or something like that. This has become the legal reasoning for the judge to postpone for the some days only. This is not preparing, but the judge can make a discretion like that, based on the legal reasoning that the trial is postponed because of the connection is bad, of the not connected quite well with the parties or the witnesses like that. And the postpone is already mentioned in the circular letter of the Supreme Court only. So like that.
Thank you, Bu Ayu.
Thank you, Shahira. Thank you, Sil. Anything else?
Okay, that's the answer from Shahira question. Perhaps Shahira has another question. Is possible? Oh, okay. He said no. Thank you, Prof. Okay. Is there any other questions, please, or perhaps opinion? Because I think the discussion will be more interesting if we can see how e-court in another countries applied, perhaps in Malaysia or Singapore or any other countries, perhaps.
Yeah, please. Good idea, Mr. Sil.
I'd like to share the experience, perhaps the knowledge regarding the e-court implementation, because I think Indonesia started the e-court in 2018, right, Bu Ayu? So
yeah, 2018, yes, correct.
Not early. I think there are a lot of countries that already
applied, implemented e-court, like Singapore, already
yes,
implemented,
Indonesia. So perhaps there are some. Is there some
experience?
Sharing?
Experience, that you can share with me right now, please? If there is any experience.
Is there any?
What about in Malaysia, the e-court in Malaysia? I
That's
think
a
there's
good
a participant
question, Bu
from
Ayu.
the,
Yeah,
I think
Malaysia.
there's Dennis is from UKM. Can we know about how the implementation of the e-court in Malaysia?
Yes.
We are encouraged to learn and to know about it.
Please, Danish, if you don't mind, you want to share your thoughts
Or
or
anyone.
experience, or anyone else?
Yes.
Okay.
I'm not getting wrong. I'm not sure about the econ in Malaysia, but I think we start to do the econ now because of the pandemic, and all the econ in Malaysia is very fast in doing the trial. Yeah, I think it's same as Indonesia in some sense. Yeah.
Okay. Thank you.
Thank you, Danish.
Thank you, Dennis.
Perhaps another.
Another?
Okay. We have another question, Bu Ayu, from
Yes.
Eliza Julie from Universitas Diponegoro. I want to ask about the trial process of the defendant and his or her lawyer not being present at the online trial continuously. Will the judge continue to postpone the trial, or are there other actions to overcome this? Please, Bu Ayu.
Okay. Elisa, I will try to ask here. If the lawyer, if the lawyer not being present at the online trial continuously, so the judge will postpone the trial, for the first time. The judge will postpone, and he will ask the principal party, the party, why the lawyer not come to the court, and then it also if it is happen again for the second trial, and the judge will also postpone again. Will maybe because I'm not read clearly about the regulation about the lawyer. Maybe the court will issue in the letter, and call the lawyer, to ask the lawyer to come to the judge and explain why he does not come, or why he didn't come to the trial. It means that if the lawyer want to resign, for the as the parties lawyers, she or he has to make a resignation letter, that he will not to be the lawyer again. This letter has to be submitted again to the application, so the court will knows and will note it down, that this lawyer will no longer the lawyer of this plaintiff or the defendant, like that. It means that there should be a letter from the court first. If there is no reaction from the lawyer, will he or she will come or not to the court. Ethically, if he does not want to become the lawyer anymore for the defendant or for the plaintiff, he should make the resignation letter to the party and also to the court. So the court will notice, that this lawyer will be no longer lawyer for the party, like that. He also postpone after there is the clearance, after the clarification from the lawyer, yes or not to be become longer lawyer for the party. Thank you, Sil. Mr. Sil.
Okay, Bu Ayu. Perhaps I have something to ask more, Bu Ayu, regarding this question, because she asked, what if the defendant? So I mean, if the defendant also not come, not only the lawyer, but the defendant it himself or herself don't show up in the court. So not only the lawyer, if the lawyer, can see that if she or he doesn't want to be lawyer, just please resign from the client. I mean like that. But if the defendant don't show up,
If
in
the
court,
defendant did not show up to the court,
yeah,
yeah, nor the lawyer did not come to the court. So both of them did not come to the court.
from what I read, both the defendant and also the
All both
lawyer.
did not come to the court. The court will make the second summons as the regulated based on the regulation. Yeah, based on the regulation, the court will make the second summon. Correct? Yeah, the second summon. If they still no response, they will not come to the court, and then the court will continue without their presence.
Or uh,
You will
first
add, please.
decision, right?
Yeah,
Yeah,
first
yeah.
tag in civil. Yeah.
Okay. Thank you, Bu Ayu. Is there
Yeah.
any?
Thank you, Elisa.
Yeah. Perhaps Eliza want to add something or want to ask more, please.
That's all, sir. Thank you, Matt.
Okay, Elisa. You're welcome.
Now we have another question from Danish. I also have a question where in case management where there were always problem of non-attendance either plaintiff or defendants, can court post a strict regulation where if they are unable to come physically must attend virtually? Ms. Bu Ayu?
Yeah. In case where there are always problem for non-attendance, either plaintiff or defendants, can court post a strict regulation where if they are unable to come physically, must attend virtually. This is based on the what court, yeah. Because for private and for administrative court, yeah, the plaintiff and or defendant, it is not necessary for them to come personally because they are already they can use the lawyer or the advocate. Yeah, for the it is different for the criminal case. For the criminal case, yeah, they have to come, yeah, personally. Can the court post a strict regulation? Yes, if needed only. The judge, yeah, will read the case, will read the case, will read the case first, yeah, and then will, if necessary, I already said, yeah, if it is necessary and based on the regulation, yeah, the court can ask them personally to come to the court. Even they use the lawyer or the advocate when the judge need their witness or needs their explanation to come, yeah, to hear directly from the party principal, yeah, from the party principal. So the court here can ask officially for them to come personally to the court. In this, if it is in e-court, it means that they can attend virtually. Yeah, like that. It is clearly, or I have to explain again.
Yeah, thank you, Bu Ayu. Please, Danish, if you like another explanation, perhaps. Yes, perhaps it is clear, Bu Ayu.
Yeah, court can possess. Okay.
So, is there any question left, please? If there are any more question, not only question actually, as I stated before, we can just share your opinion or share your experience here, because we hope this forum will be more
Colorful.
rich, okay, more rich with another perspective from another countries. Please, is there any more questions or opinion? Okay, Bu Ayu, actually I have questions, but this is from perhaps the not the participant, but the audience from YouTube. So I will read it for you.
Okay.
Questions. Okay. Besides being practical, e-court also has some drawbacks or obstacles. One of them, facilities and infrastructure in some areas are not adequate, and also not many lawyers who use e-court. How you respond the problem? So this is regarding the facilities or infrastructure in perhaps in a remote area. So they are not the same with the big cities facilities. So they have obstacle to implement e-court, and also what will we do about the lawyer that don't doesn't want to use the e-court system?
Yeah, if the lawyer does not want to use the e-court system, it is not a must. Yeah, it is not a must because there is no regulation and e-court that said that you have to use the e-court unless you will get a punishment. There is no statement like that. Yeah, there is no statement like that. So mostly because based on this condition, yeah, so they choose the e-court. Yeah, there's the e-court. And then what about the lack of condition or the obstacle in the facility? Yeah, obstacle in the facility, in the courtroom or in the region or in the area.
Yeah, perhaps in the courtroom, and also in the court that located in a remote area or in the
Okay. Yeah, in the court which is located in the remote area, it is different. It is very difficult. Yeah, I can imagine too. It is very difficult. Yeah, but since there is the commitment of the Supreme Court, yeah, so the Supreme Court has to make a budget. Yeah, budget for the its court in all the Indonesian yeah, to prepare for the video conference like that. Yeah, I know it is very difficult. Yeah, difficult for the course in the remote area. Yeah, but since it is the program of the Supreme Court, so they have to make budget for its courts to prepare this properly. Okay, so like that.
Thank you, Bu Ayu.
Yeah.
Perhaps another participant would like to ask. Please, if you would like to ask, do not hesitate. Just write down in the chat box. Even if you want to speak directly, it's possible to just stop, just say your or mention your question. Any questions? Don't forget to fill in the attendance list. It's already posted in the chat. Okay. Attendance list for the second session. Any questions? Okay. Finally, we have another one, Bu Ayu. The question is from Eliza, from Universitas Diponegoro. I want to ask about the trial process of the defendant and his or her lawyer not being present. Oh,
already answered. Yeah.
Sorry,
the next one from Iqbal.
Okay. My question is, how does the Indonesian e-court ensures the procedural rules, ethics, and etiquette being adhered to? And as we all know, the court proceeding must be in an open court. So how does the Indonesian e-court assuring this rule being followed? So the court should be open and terbuka untuk umum in Indonesia, perhaps.
Yes.
So how to make it open when they are online, perhaps like that.
Yeah. Thank you, Iqbal, for your questions. How does the Indonesian e-court ensures the procedural rules, ethics, and etiquette being adhered to? And as well as we all know, the court proceeding must be in an open court. So how does the Indonesian e-court assuring this rule being followed? Yeah, it is very difficult, yeah, to ensure about that, Iqbal. But ethically, that if we came to the courtroom, yeah, we automatically have to follow and to respect to the courtroom. Yeah, this is based on our ethic again. Yeah, the judge, since it is not easy for other people, yeah, to follow the guide, the principle, yeah, about the rules also. So the courtroom, yeah, the judge will read, before the trial is being ready, they also will read about the regulation that all the attendees, yeah, attendants also, yeah, have to regulate, have to follow, yeah, have to respect to the regulation in the courtroom. It is very difficult, emang, yeah, I know it is very difficult, but everyone, I think, has an ethic, yeah, to respect to the courtroom. Yeah, that is all.
Okay, is that clear, Iqbal, or you still have another opinion or question, perhaps?
Yes, it is. Thank you. Thank you, Doctor.
Okay, okay, okay.
Okay, Iqbal.
Okay, perhaps that's all for the Q&A session. Now I will let Bu Ayu to share his closing statement, please, Bu Ayu.
Okay, my closing statement that the Supreme Court of the Republic of Indonesia, yeah, has already implemented, yeah, the information technology for the court in all the proceeding in Indonesia. This implementation of the information technology is to make people easier to get access to justice for everyone. Yeah. But on the other side, also have to uphold the independence of the judiciary in courts in Indonesia. That is my closing statement, Mr. Sil ID. Thank you.
Okay, thank you, Bu Ayu, for the very nice presentation and also for the very good answers on the Q&A session. So perhaps that's all of the participants for this session regarding the Indonesian e-court. Thank you for your kind attention and for your questions and opinion. And I will return it to the MC. Assalamualaikum
Yeah.
warahmatullahi wabarakatuh. Good afternoon all.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Mr. Sil ID.
Okay, thank you very much, Mr. Zelaidi, and absolutely, Dr. Ayu Putrianti, for your comprehensive and insightful material. It's actually very eye-opening. Okay, well, ladies and gentlemen, now we will hold a photo sessions. In order that for all the participants, please turn on your camera. Come on, guys, please turn on your camera. We want to see your beautiful face. All right, I think that's all. Okay, on my side, in 3, 2, 1. Okay, once more, in 3, 2, 1. All right, thank you very much, everyone.
Thank you very much.
Okay, finally, we're in the end of the sessions. It has been a great and wonderful morning with all of you. May what we had conducted today will be useful for us. As the master of ceremony, on behalf of committee, would like to apologize if there are any mistake during this event. That's all for today. See you in other sessions of summer course Lex Proficia 2021. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Salam kebajikan untuk kita semua. Stay safe and stay healthy all. Have a good rest. Bye.